Good afternoon. I'm Angel Coloniso, the Clerk and Comptroller for Manatee County and the President of the Florida Court Clerks and Comptrollers. We appreciate your attendance today for this important session on the recent changes to the Florida Rules of General Practice and Judicial Administration 2.420. And as elected officials and members of our statewide association, Florida's Clerks of Court and Comptrollers share a common mission. We are united statewide to protect the public trust. This is a mission that we do not take lightly, and it's why we go through more than 250 hours of training and certification programs to understand the complexities of our role and the complexities of the issues we face. We are here today to break down the changes to Rule 2.420 that appear simple on the surface, but are actually quite complex. Many of you are aware of these changes, but we felt it important to hold this presentation to provide more information about the processes and what exactly they mean for you as attorneys and legal professionals. There will be a brief question and answer portion at the end of this presentation. Please use the Q&A feature, the chat feature, to ask the panelists questions throughout the presentation. Before we begin, I would like to introduce our panelists, all of whom, including myself, are attorneys, licensed attorneys in the state of Florida. As mentioned in my opening, I'm the Clerk of the Circuit Court and Comptroller for Manatee County and the current President of the Florida Court Clerks and Comptrollers. I have nearly 30 years of experience as a public servant in Manatee County and as an assistant attorney and as general counsel for the Manatee County Clerk's Office, until being appointed in 2015 as Clerk of the Circuit Court. I received my bachelor's degree from the University of South Florida and my law degree from New England School of Law. Our next panelist will be Clerk Gregory Harrell of Marion County, Clerk of the Circuit Court and Comptroller. Greg is the Clerk and Comptroller for Marion County. Prior to serving as clerk, he worked as general counsel to the Marion County Clerk's Office, starting that role in 2013. Greg graduated from the University of Virginia before earning his JD from the University of Florida, where he was a member of the Florida Law Review. Next is Tiffany Moore Russell. She is the Clerk of the Court Clerk for Orange County and a native of Orlando. She received her bachelor's degree in political science from the University of South Florida and her Juris Doctorate from the Florida State University College of Law. She was elected and sworn in as the Orange County Clerk of Courts in November of 2014. Prior to that, she served 2 terms as an Orange County Commissioner and was the youngest commissioner to serve Orange County. Clerk Russell recently sits on both the Domestic Violence Commission and the Domestic Violence Task Force. Our next panelist is Paul Resendorf. He's representing the Florida Bar today. Mr. Resendorf is a civil, trial, and appellate attorney practicing in Palm City, Florida. His work on Rule 2.420 began at the beginning when he served on the Supreme Court's Access to Court Records Committee that first wrote this rule. Thereafter, he continued to work on the development of the rule during many years that he served on the Supreme Court's Florida Courts Technology Commission and the Florida Bar's Rules of Judicial Administration Committee, which were jointly responsible for its implementation and periodic amendment. The Florida Bar offered to have us present on changes to Rule 2.420 today. As attorneys and legal professionals, it's really important that you understand and adhere to the new rule changes to protect confidential information you may be working with while filing on behalf of a client. It's important to note that before we discuss the new language of Rule 2.420, that as a panel of clerks of court and attorneys, we are here to speak to the changes to the rule, but we are not speaking on behalf of all clerks. That being said, I'll turn it over to our first panelist, Clerk Greg Harrell.
Good afternoon, everyone. Thank you, Clerk Coloniso. I appreciate everyone joining us today. Before we jump into the specifics, I'd like to start off by displaying a brief video that explains the issue in a pretty simple 30,000 foot kind of way, and then we'll get into a bit more detail from there.
Attention attorneys, legal professionals, self-represented litigants, and anyone filing court documents in Florida. Based on a recent Florida Supreme Court amendment to Rule 2.420, there are changes that you need to know about when filing documents with confidential information. The changes affect most civil cases, including small claims cases for legal disputes $8,000 or less, county court civil cases for legal disputes between $8,001 and $30,000, and most circuit court civil cases above $30,000 and appeals from county court. They do not apply to criminal, domestic relations, probate, or special case types. Here's what you need to know. Rule 2.420 already requires filers to protect confidential information in the documents they file. But now, clerks of court are no longer required to review and remove confidential information in small claims court filings, county court civil cases, and most circuit cases unless notified by the filer. That means that in these cases, filers are now solely responsible for identifying confidential information contained in these court records to ensure it is appropriately redacted. Starting July 1st, 2021, it's critical that you properly identify this information to prevent it from becoming publicly accessible. Here's how. If the filer who is drafting a document believes it contains confidential information, they should first exclude it if it isn't necessary information. Or second, complete a Notice of Confidential Information within Court Filing form before filing. To access this form, you can contact your local clerk of court or visit their website. These forms are available in every county, and they collect the same information. Filers are required to identify the precise location of all instances of confidential information within the document, including page numbers and attachments, appendices, and exhibits. On many forms, you are required to select whether the entire document is confidential or to identify each instance of confidential information. Filers are also required to identify the type of confidential information that applies. According to the rule, there are 23 types of confidential information that can be redacted, including social security numbers, bank accounts, victim identifying information, and more. If a notice is filed but the information is not considered confidential, the clerk will notify the filer within 5 business days, locking the document as confidential for up to 10 business days to allow the filer to file a motion to determine confidentiality of court records. If no motion is filed after 10 days, the information may become public. Once the motion is filed, the clerk will keep the document in a locked status unavailable for public viewing until the court rules on the motion. Please take the time to carefully review and understand these changes. It's up to filers to identify this confidential information and protect it from becoming publicly accessible. And it's up to attorneys when filing on behalf of a client. For attorneys, failure to identify the information properly could result in sanctions or bar disciplinary action. If you have any questions, please contact your local clerk of court. Visit the FL Clerks website to learn more.
All right, and just for future reference sake, I wanted to let everybody know that that video and a link to it, I think we make that available at the end of this presentation, but it's certainly something we can make available to you moving forward, as it's a nice overview of what we're about to jump into in a little more detail now. As the video mentioned, clerks maintain and manage access to public documents that often contain confidential information. We are directed by rules set forth by the Florida Supreme Court, and we cannot operate outside that authority. For a little over a decade now, as Mr. Regensdorf can attest to, clerks were responsible for independently reviewing documents to redact certain confidential information in all case types, including small claims cases, county civil cases, and most circuit civil cases, regardless of whether we were notified by filers of such information. If we could go to the next slide, please. Thank you. This automatic process performed by clerks has undeniably prevented information like social security numbers, credit card numbers, and certain identifying information from being revealed to the public. Although there are many other types of confidential information that can be protected by completing a motion to determine the confidentiality of those court records, these 23 types of confidential information that are identified in the slide before you are the ones that can and should be protected by filers under Rule 2.420 by using a notice of confidentiality. Most importantly, for our purposes here today, is the fact that the Florida Supreme Court recently adopted an amendment to the rule removing clerks' responsibility to independently protect this information in most civil cases. Next slide, please. Here specifically is where the changes apply. And I'm going to quote some language from the amendment itself. The amendment specifically states, quote, "The clerk of the court shall not be required to designate and maintain information as confidential unless the filer follows the notice procedures," end quote. In small claims cases, county civil cases, and most circuit civil court documents. As the video mentioned, there are different jurisdictional thresholds for small claims cases, county court civil cases, and circuit court cases. Small claims cases are those, as most of you know, for legal disputes of $8,000 or less. County court civil cases are presently cases filed for disputes between $8,000 and $30,000. Those jurisdictional limits are subject to being increased soon as well. And presently, most circuit court civil cases are those above $30,000. So to be a little more precise in what we're talking about here today, the amended rule affects small claims cases, county civil cases, and most circuit civil cases. The cases that are not affected by the amendment are circuit civil Jimmy Rice cases, otherwise known as involuntary civil commitments for sexually violent predators, other cases stemming from sexual assault, and as of right now anyway, medical malpractice filings. It's important to note that the case types listed under the heading on this slide where the rule change does not apply are the cases where clerks are still required to independently review and protect the confidential information set forth in Rule 2.420 D1. The case types listed under the heading where the rule change does apply are the cases where the clerk is no longer required to independently review and protect the confidential information. So really the gist is this, folks. You, the attorney filer, are still responsible for notifying clerks of all protected information within each of these case types seen on this slide. But our role as clerks to independently review for the 23 designated categories set forth in Rule 2.420 D1 will no longer happen in most civil cases. Next slide, please. So just to kind of reiterate and be as clear as possible, what does this mean for you? Effective July 1 of this year, so this is already in effect, clerks of court are no longer responsible for independently reviewing all filed records to further identify and redact confidential information protected by the rule. Rather, filers are now solely responsible for identifying confidential information in most civil court records to ensure it's properly protected. At this point, I'll turn things back over to President Coloniso.
Thank you, Greg. As the president of FCCC, I would like to emphasize how important it is for filers to understand what this shift in responsibility means. We understand that the amendments were made with the intent of speeding up access to court documents. We fully support timely access of public information. We also understand the importance of protecting confidential information and have worked hard to mitigate the risks before and during this transition, which is why our association submitted a written comment. Again, filers, it is now up to you to identify these 23 different types of confidential information for clerks to protect.
Next slide, please. Thank you, Angel. With clerks no longer being required to independently identify and protect these types of confidential information in most civil cases, it really is now all that much more important that filers, including attorneys, adhere to their responsibilities under the rule. Here are some important things filers should keep in mind. If you are a filer drafting a document and believe it contains confidential information, you should exclude or minimize the information if it is not necessary and can be omitted or minimized. Or if the information is not among the types of information listed in Rule 2.420 D1, you should complete and file a motion to determine confidentiality pursuant to Rule 2.420 D3. If, however, the information in question is among the types of information listed in Rule 2.420 D1, you should complete a notice of confidential information within court filing before or along with the document you're filing. Next slide, please. Notices of confidential information forms can be found on most of your local clerk's websites. But if you are unable to find them for whatever reason, please just contact your local clerk. Next slide. As has been the case since the rule was enacted, filers are required to identify the precise location of all instances of confidential information within the document, including page numbers and attachments, appendices, and exhibits. And we're going to talk about that in a little more detail later, but this is the issue where we see the most lack of compliance with the rule. On many forms, you are required to select whether the entire document is confidential. Next slide. If a notice is filed, but the information is not considered one of the 23 types of confidential information listed in Rule 2.420 D1, clerks will notify the filer, as was mentioned in the video earlier, within 5 business days, locking the document as confidential for up to 10 business days to allow the filer to file the motion to determine confidentiality. If no motion is filed after 10 days, the information may become public. Once the motion is filed, the clerk will keep the document in a locked status, unavailable for public viewing until the court rules on the motion. So as attorneys, paralegals, and legal staff, it is critical that you exercise diligence in reviewing documents prior to filing to ensure that you do not subject client information to public exposure. Clerks and filers will retain, just to be clear, dual responsibility to identify confidential information in all other types of filings for family, criminal, juvenile, and probate cases. But again, please contact your local clerk of court or visit their website to access their notice forms. Thank you. And at this point, I'll turn things over to Clerk Tiffany Moore Russell.
Thank you, Greg. And so hopefully, based on everything discussed, it's clear how filers should handle filing documents with confidential information. But now I'd really like to talk to you about why this is so important. The reality is, if the forms are filed incorrectly or aren't filed at all, confidential information could become publicly accessible, leading to some dangerous situations. It affects real people, and this is why clerks and our partners are encouraging filers to understand the changes. So here are a few examples that illustrate the risk not filing a notice of confidentiality or filing an incorrect or incomplete notice of confidentiality could lead to. So one of them could be identifying information about domestic violence victims, including their address, or which could get into the wrong hands. Social security numbers and bank account numbers becoming publicly accessible, leading to fraud. And protected medical information and juvenile delinquency records becoming publicly accessible. Now, I'd like to turn it over to Paul to talk about the importance of adhering to the rule of change from the perspective of practicing as a practicing private attorney.
Paul, you're on mute.
I told you that was going to happen. Thank you, Greg. Excuse me, Clerk Harrell. other than being technologically inept, let me go back a little bit and give you a little bit of background. When we started to change the world from a paper system back in the early 2000s to the wonderful electronic system we had now, it was an incredible technological struggle. And I want to start off by saying that every member of the bar, every member at bench owes the 67 clerks in their organization a tremendous thank you for getting us through that. The system we have now works extremely well, and it's principally through the efforts of the clerks, and I want to thank them for that. But I want to start at the 30,000-foot level, because the problems we had writing this rule was we had to find a way that electronic documents could be sent from somebody at his or her computer to a court file without anybody seeing them, and yet somehow that court file had to identify and protect certain information in those electronic documents that was confidential. And it was an incredible struggle to try to find out how to do that and make it work in an electronic world. The principal way that the Supreme Court decided to do this back about 11 years ago was to place the primary responsibility on the lawyers, the filers, each one of us, to know and identify all of the types of confidential information in the statutes and elsewhere and protect it. The clerks had certain limited responsibilities in 23 types of cases, but that wasn't just us. The lawyers had complete obligations to protect that information. We're the ones who put things into court files. We need to protect it. And you need to know that there are about 1,000 statutes in the state of Florida that create different types of confidential information. Some of those 1,000 statutes don't really apply in a court context, but some of them do. So if you've got one of those unusual things that it's not in the 23, you've got to learn out how to protect that. Only the legislature can create confidential documents. Judges no longer have that ability since the 1993 constitutional amendment. So we, as the lawyers and clerks and court, we are stuck with whatever the legislature creates. They've created over 1,000 different types. And we as lawyers need to keep all of that out of the court when it's appropriate. Now, there's been some talk about these 23.
Oh, Paul, you're on mute again.
It's maybe better when I'm muted, I don't know. Let's talk about the 23. They are not anything special. They're not unique. They're not the most important. What they were the 23 types of statutory confidential documents that the clerks could identify themselves because they were relatively easy to identify in a court context. You didn't have to go to law school to identify it. A skilled and trained clerk could do that. So the way we decided then was we would add the clerks as an additional protection. Lawyers had their 100% obligation to protect the file from all confidential information. And the clerks had an additional obligation for 23 specific types, but only 23 specific types. And the way you draw the court or the clerk's attention to those 23 is you file a notice of confidentiality in court filing. Now, the movie you saw earlier, very helpful, said you should identify the type of information in the document. Don't do that, because if you identify the type in your notice, that notice is a public document, and they're going to know what it is you're trying to keep confidential. If a person is a victim of domestic violence or has HIV, you don't want to say that's the category you're protecting, because you will in fact disclose the category. What you need to do on this form, and this is critical, you need to tell the clerk precisely where your confidential information is. Page 37, paragraph 72, subpart A. Don't tell them what it is, because if it's in those 23, the clerks will understand that. They can recognize those because they're trained to recognize the material in those 23 categories. Now, you can only use that notice for the 23, because that doesn't go to a judge. That goes to a trained clerk, which pulls that document out of the electronic filing. It doesn't immediately become publicly accessible. And then the clerk checks paragraph, page 37, paragraph 72, subpart A, to see if you've got something in that subparagraph that is confidential. Social security number, victim of domestic violence, HIV, whatever it may be, one of the 23. That's all the clerk's going to look for. And if they don't find it, they've got a problem. So you have to be precise and specific as to what it is that you think is confidential. Now realize, if you don't need to put that confidential information in the court file, the best thing to do is just don't put it in there. Just delete it, edit around it. If you don't need to put in somebody's social security number or status. So that's how you use the form. Do not put down what it is that's confidential. Just specifically identify where it is. Now, the other way you do it is with the other 970 some statutes, because on those matters, clerks have absolutely no ability to protect the court file. All you can do with that is you have to go to the judge. You file a motion to determine confidentiality. You tell the judge why those things have to be kept confidential. The clerk will then hold those matters for a defined period of time to allow the judge to act. But once the judge acts, he or she will enter an order, and then the clerk will either protect that document or release it. But the clerk has no basis in doing anything on those other 970. But you do. And this is the most important thing I want to communicate today. Lots of talk today about how this rule has changed, big changes. You need to know about it. Well, there's things you absolutely need to know, but it's not that there's been a change for lawyers, because for lawyers, your obligation continues exactly the same 100% as it's ever been. It's exactly the same. Can you go to the next slide, please? Or maybe it's gone. Okay. Your obligation is the same as it was 11 years ago. It's still a 100% obligation. If something gets in the court file today improperly and it's confidential, the lawyer has probably made a mistake. He or she either did not tell the clerk about one of the 23 or didn't file a motion with the court about one of the 970 to see if the judge agrees. So folks, this is critically important. The monkey is now totally on our back. It used to be that we had belts and suspenders. We were the belts and the clerk was the suspenders, or vice versa. And together we kept our pants up. We don't have that protection anymore, folks. Starting July 1, it's all on us. And if we don't do it in every single kind of case, we're in trouble. Now, the clerks will still back us up in those other types of cases that Judge Harrell talked about. But in the basic civil cases, we're on our own. Something gets in there, it's on our neck. And remember this, when you're looking at your filing and trying to determine whether there's anything in that document that could be confidential, don't just look at your 8-page motion or your 10-page memorandum. Look at the 37-page appendix that you filed, or the 400 pages of exhibits that you filed, which may be bank records or attachments from contracts or medical records, Lord knows what. But the point is, you as the filer, lawyer or filer, are 100% responsibility, not just for the typed document you put on your computer, that 8-page motion, but you're also responsible to scour and eliminate or redact or tell the clerk about or ask the judge about every single page of every document that's in the appendix or exhibit or whatever. This is our job, and as I think you're about to see, I'm embarrassed to say that we as a profession are doing right now a horrible job. And that's why this seminar today is so important. And I'll speak about it again immediately after the next section. Thank you.
Thank you, Paul. And unfortunately, too, the likelihood of confidential information becoming publicly accessible is actually pretty high. So to illustrate the risk, first, in February of 2021, 5 clerk offices conducted a 1-week study of case filings to understand the risk of the rule change. The study showed us that 21% of filed documents subject to this rule change contained confidential information that was not redacted or notified for redaction by the filer, but was identified and redacted by the clerk. That's a significant percentage of filings with information at risk of exposure. Since the study was conducted prior to the rule change, clerks identified and redacted the confidential information. Again, this is additional review. This This additional review is no longer required under the court's amendment. Next slide, please. All right, second, more recently, 2 clerk's offices have tracked filers' compliance with the rule change since its implementation on July 1 of this year through August 25th of this year. So during that time, there were 597 notices of confidentiality filed in the case types affected by the rule change. Of those notices, 89 were found to be compliant and 508 were found to be non-compliant. In other words, we're looking at a staggering 85% of the notices of confidentiality were not compliant. So if you look at the number of correspondence column, this tracks the issues in each non-compliant notice based on the correspondences mailed to each filer. This indicates that very few of the notices were considered not eligible, meaning that most contained confidential information and were eligible. But in more than 75% of cases, which is the 449 out of the 597, the notices were missing the location of the confidential information in the filing. The last column shows that there are 1,680 documents that needed redaction because it contained at least one of the 23 types of confidential information, but a notice of confidentiality was not filed. The biggest takeaway from this is that out of the 2,277 total documents that contained confidential information, only 26% included a notice of confidentiality, and only 4% included a notice that was correctly completed. Given this data, many clerks are concerned about the amount of confidential information at risk of being disclosed to the public during this transition in responsibility. We strongly urge you to review the changes to this rule and make sure that you and your staff are fully familiar with this rule change. We want it to be very clear. If confidential information is not appropriately identified upon being filed, it will be at risk of public release. There are a few other repercussions of not adhering to the new rules that Paul will cover. So Paul, I give it back to you.
How about that, Greg? I turned off the mute feature. Folks, let me try to be as direct as I can. Those statistics that you just saw were absolutely appalling in terms of our profession, yours and mine. It means that by one measure, 74% of the documents that have confidential information in them were not being protected in any way. Meaning those 74% of the documents simply got dumped into the public record. They're available for use by anybody, any member of the public, any data miner, anybody who wants to look at all of that confidential information can do it. And at least a few people filed notices to draw the clerk's attention to the 23 categories, but of those who filed them, only 15% of those did it the right way and told the clerk what to get done. I'm going to tell you at the end something that scares me, at least in a technical sense, but let me just go back for a minute. The easiest way to present this is that, guys, ladies, gentlemen, we are members of a profession. We're not plumbers, we're not golfers, we don't sweep streets. We are a profession that regulates itself. The court and the lawyers have passed a set of rules that says it is our professional obligation to protect the confidential information of everyone, not just our clients, but also our opponents. We can't trash the record with our opponents' confidential information, nor third parties who aren't even members of the lawsuit. It is our professional obligation. If we all complied with Rule 2.420, the numbers that the clerk just showed you would all be zeros, and the court records would be intact and they would be fine. And the public, who has the constitutional right to review its records, can feel comfortable in knowing that they can look at them and there's not going to be anything secret in there about them. The types of damage, you just heard a few examples. The two things that hurt me the most are the incremental type that are hard to assess. One of the things that the clerks used to do very, very well is find things like social security numbers, things that are often put on documents as attachments to motions, memoranda, and we forget to scour them and remove them Fortunately, the clerks used to do that. Now, you say, well, what's the big deal with a social security number? Well, if you're a data miner, if you're trying to identify little pieces of information about people in the United States and elsewhere, and you can gradually add small pieces of information, an address, a birth date, a social security number, a bank account number, a credit card number, things like this, you aggregate that data, and pretty soon they've got the ability to steal someone's identity. So it's hard to say that any one social security number caused the problem of a person's loss of identity later on to a thief, but that's what happens. So we have to protect that. The clerks used to do it, and they were great at it to back us up, because frankly, we weren't very good before. Well, we're certainly not very good now. So that's one type of exposure. The second type, of course, is the embarrassing types of things. And I mentioned a couple of them before. If you're the victim of a domestic violence or a sexual crime, you don't want that splattered all over the court file. Once it's in the court file, if it's not protected, it's a public record available to anyone who wants to look at it. Those matters aren't just embarrassing or annoying. Those are terribly, terribly painful for the people involved. So please, folks, look at the law. Learn your obligations to identify all types of confidential information. Don't go just to your documents, but go to the attachments to your documents and keep them out of there. Now, we were talking about sanctions. What can happen? What can happen as a result of this? If you read Rule 2.420, you'll see that there is very clearly a sanction rule built in. Now, I want to tell you straight up, to my knowledge, I don't believe a judge has ever sanctioned a lawyer in Florida that I'm aware of for violating Rule 2.420. I don't know why they haven't. There have been a lot of horrible violations, but that should be a sanctionable conduct. It is in the rule. Now, one of the reasons why perhaps no lawyer has been sanctioned is we had that suspenders hanging around, holding our pants up. We weren't going to be embarrassed because the clerks had our back and our pants. So thank God for the clerks, not after July 1st. We're out there by ourselves, folks. So that's one reason why perhaps there has never been a sanction order. But let me just scare you a little bit more. There's a set of rules circulating right now, a work group from the Supreme Court called something like Work Group on Improving Speeding Up Civil Cases or something like that. There's about 80 pages of new civil rules. I'm working on evaluating those for that work group on behalf of the Civil Rules Committee. You folks need to look at those rules, because every single one of those rules is laced with a new sanction power, If they're approved by the Supreme Court, and they haven't even been sent there yet, but many people think they will be, it indicates that they are going to empower our circuit and county judges to aggressively impose sanctions, actively, frequently, and in many cases without any discretion. So whether we like it or not, we are about to be on the brink of a day when courts will be awarding sanctions. I think it's a horrible way to make us perform better, but if nothing else works, I suppose sanctions are better than nothing. But let me give you one last scary thought, and it's also a professional thought. When we were writing these rules back in 2009, 2010, as I told you, one of the most difficult tasks that we had was finding a way to effectively move documents quickly from the paper onto a computer, send them to the clerk, and then place them in the court file and make them public files. We had to find a way through there to skim out all of the confidential information. The way we did it was by the rule that we've just described for you for the last hour. But the Supreme Court, at least the Supreme Court in 2009 and 2010, didn't believe us. We had to continue to prove how that system would work, how it would efficiently and effectively eliminate confidential information. And a moratorium was placed. The court allowed documents to be filed electronically. Well, that's about 10% of the use of the system. For me, in my practice, the best use of that system is being able to sit at home or in my office and access those documents from outside, getting public access to a court file. And the Supreme Court said, no. We're not going to allow public access until you can prove to us lawyers with clerk backup that these files are being properly protected. Now, my thought and my fear is this. If we took the last slide that was just shown to you from only 2 counties that showed a success rate of somewhere between 15 and 26%, and that 26% is inflated. If we showed that to the Supreme Court today, and if today's Supreme Court had the degree of importance and protection interests for the public's confidential information that the Supreme Court of 12 years ago did, I will tell you right now, the Supreme Court of 12 years ago would shut down public access to our electronic records tomorrow, because the record that these clerks have demonstrated of our inefficiency and unprofessionalism is frankly shocking. So, folks, it's really pretty simple. If you think it might be one of the 23, file a notice to the clerk. If you think it's not, but you still think it's confidential, file a motion, let the judge decide, and proceed in accordance with the rule. If you have any questions, the clerks are tremendous resources. They'll be happy to help you out. Give me a call. I'm in Palm City. You can reach me through the Florida bar. Not that I'm an information source, but I talk to lawyers every day on this stuff. We have got to do better. We are not acting as professionals, and I like to think we are. So best of luck. Again, thanks to the clerk for this wonderful program and for your 10 years of work giving us the electronic court system. Thank you.
Thank you, Paul. I appreciate your wisdom and your experience there and the sort of practical day-to-day insights. I would point out one other thing from a clerk's perspective, that as we sort of grapple with this new territory where in small claims cases and county civil and most circuit civil cases, we are no longer required to independently review for the items listed in the rule. Where we are most seeing, and this was teased out by some of the data that Clerk Moore Russell showed before, but I just want to reiterate that where we're seeing the biggest issues, number one is just in not filing the notices to begin with, but number two is in where the notices are filed, the notices end up being frequently deficient by not adequately identifying where the purported confidential information is. So where you can most help your client, and frankly, most help your clerks, is to specifically identify. I don't want to throw any particular practice area under the bus, but we do see in high volume practice types some deficiencies in notices that are a little too vague. They will just sort of indicate there may be account numbers in this document. They're not even committed to the fact that there is confidential information. They just sort of suggest there might be, and they certainly don't go as far as saying that there is and where it is precisely. So practice sort of pointer there is to not only do the notice and think you've met that mark by doing it, but do it with precision to identify the information. At this point, Clerk Colanesso, I think we'll hand it back over to Clerk Moore Russell.
All right, thank you, Clerk Harrell. And so again, as clerks, our foremost priority as custodians of the court records is protecting the public. So for 2.420, this starts with educating attorneys and informing residents about these changes. Luckily, we're not in this effort alone. We are fortunate to have strong partnerships with both the Florida Bar and the Florida courts, and we are very appreciative of their support as we navigate the parameters of the rule as it now stands. So to help communicate and provide guidance on the changes to Rule 2.420, our association has put together some resources for you to use and share at your discretion. The first is the animated video you saw at the outset of this presentation that provides an overview of much of the information we've presented today, discussing the changes and their effect on filers. The next resource is a website that houses more materials and provide additional information. And as you see, it's listed here. And last, we want to encourage you to visit your local clerk's website as well. And if you have questions, please feel free to contact us. We are happy to assist with this rule's compliance to ensure confidential information remains protected. At this time, I will hand it back over to our president, Clerk Colanesso.
Thank you, Clerk Russell. Again, we strongly suggest that as attorneys and legal professionals, you review the amendment and become fully familiar with the rule change. Having protected this information for almost 10 years, clerks are well equipped to help you if you have any questions, and we encourage you to reach out. This is new territory for all of us. While we may no longer be reviewing these types of case filings for specific information, our number one priority is to ensure confidential information of residents remains protected and while providing the public with timely access to court records. We have conducted many outreach efforts and to alert professionals and the public about these changes, and will continue to closely monitor this issue at a local level. We hope that you utilize the resources we have available, as well as those provided by your local clerk of court, to adhere to these amendments to Rule 2.420. At this time, I'll open it up for the panel. I know we have some questions. Greg, did you want to read off a couple of question and answers that were earlier on?
Hey,
tried to
Clerk
keep
so
up.
this is Patrick. I was going to kind of
Oh, yes.
moderate some of the questions.
Okay. Oh, thank you.
Yeah, so I'm just going to go through some of the questions that we received in the chat during the presentation. I think the first thing I would just want to address is that a video of the presentation will be available on the Legal Field website afterward. Let's go through.
Patrick, I did want to clarify one question that I think came through by chat, and this is the danger of doing things in real time on the fly here regarding probate specifically, and maybe an inconsistency between the video and the slides. But I would point out that probate is an area where clerks were formerly required to do the independent review, but those are no longer that they fit within where we have been taken out of the process. So the filer still has the obligation, the same obligation they have all along, but the clerks no longer have the independent review. So I apologize if the answer in the chat and any other areas was inconsistent in that regard, but go ahead.
Okay, thank you, Clerk Carroll. Okay, so the next question we have is, are motions to determine confidentiality also confidential? Do we need a notice of confidentiality to accompany such a motion?
My answer there, and I'll defer to the other clerks too to get their input, but I would say that the motion itself per the rule is not in and of itself confidential. I mean, you can always ask a court to keep it confidential, but Rule 2.420 doesn't make the motion itself confidential, which is important. Why, when doing such a motion, you don't inadvertently telegraph in the body of the motion the type of information you're trying to protect. Let's say it's HIV results, and you throw that out, and you're implicitly, giving away the fact that the person in question may be HIV positive. So you need to be careful about that. But the answer to the question is the motion is not in and of itself per the rule confidential.
Yeah, I agree with that. That was Daniel's question, I believe. The reason for that is that courts cannot create any confidential documents. Only the legislature can by a 2/3 vote of both houses. So we cannot say that a notice of confidentiality form is confidential, because then we would be creating a confidential document. Same with a motion. So you have to be careful in your drafting of the motion or the notice to make sure that there's nothing in there that expressly discloses your confidential information. Obviously, it has to get to the court, and the court will eventually rule on it, and they may be able to withdraw it from the file. But at the beginning, the clerks do not have the authority to keep anything confidential other than the documents attached to the motion and the notice. Those are held pending action by the court if it's a motion, or are held if the clerk agrees with you on the 23, then they're placed and held as confidential. I hope that answers Daniel's question.
All right, thank you, Paul. So our third question is, I did not see probate/guardianship listed. How does 2.420 affect these cases?
I would go back to the same answer before on the earlier question. Guardianship, I would point out though, in I believe it's subdivision 15, Roman numeral 15 of 2.420, let's see, 21B. D15 has specific components of guardianship that are confidential, and you, the filer, then have to, as you always have had the responsibility, to identify if you are filing such information by way of a notice, but the clerks no longer have the independent responsibility there.
Thank you, Clerk Harrell. So question 4 is, upon the filing of a notice of confidential filing and motion outside of the 23 categories of 2.420, would only the person or the attorney that filed the notice and motion have access to the protected information until a ruling is made by the court? Would the other party or other party's attorney have access to the information before a ruling is made?
Well, first, let me just clear up the procedure. You should never file both a notice and a motion. If you file a motion, it's because it's not one of the 23. You're saying, judge, judicial officer, black robe person, is this something that we can keep confidential? If it is one of the 23, you file a notice, and then the clerk either agrees with you or doesn't. The motions themselves are not confidential. The documents are until the court or the clerk makes a decision on that document. I'm not sure that answered the question, but the procedure is not to file both a notice and a motion. There shouldn't be one of each.
Thank you, Paul.
And I can just share, Patrick, it's often, maybe depending on that clerk's system, once we receive a notice or a motion, we lock it down until either the ruling or we've redacted the document. So during that lock period, no one has access to it.
Okay. Thank you, Clerk Russell. Our next question is, what is a case that is confidential by law or considered confidential by law?
That would be something, for example, like a juvenile, a case confidential by its case type.
Yeah, or an adoption case may be confidential. Right. And if you are in an adoption case, you don't need to worry about identifying by notice or motion documents in that whole case, because everything in that case from beginning to end is kept confidential, or certain types of juvenile matters, things of that sort. But in terms of civil cases, I don't know of any cases per se that are confidential. Patrick, can I address something that I saw in one of these questions?
Mm-hmm.
It was a question about redacting. To me, redacting is taking some sort of either a black marker or an electronic marker and covering over the lettering on a page. If you need to do that to file something and you file it in that format, it is redacted. You have not filed anything that's confidential. You just filed something with a black line on, but the judge doesn't get to see what's under that black line. If you need the judge to see it, then you need to have either the clerk redact it because it is one of the 23 types, and they will redact it for public viewing, but not for the judge's viewing. Or if it's a motion, it will go to the judge, and the judge, if he or she agrees, will redact it or order the clerk to redact it. But if you want the judge to see it, but not the public, you can't do the black marking on it. You just have to hope that either the clerk or the judge accepts your argument on confidentiality.
Gotcha. Thank you, Paul. So our next question is, given the history of lack of compliance before and after the new rule, don't you think a period of notifying lawyers of non-compliance for a period of time would be in order? Lawyers would be responsible for non-compliance, but a clerk backup system notifying the lawyers to create awareness and show how to do it right could result in awareness through the bar.
I just answered that one. I don't see it anymore, but I did type an answer. The clerks did ask for a grace period of sorts in their response, in their answer, but that went without being implemented. The amendment passed without that implementation.
I don't think lawyers are entitled to a grace period. They've been having this. Realize the lawyer's obligation has not changed one nickel. It is still 100% protect all confidential information. The only thing that's changed, and I realize for the clerks, it's a big deal. They stepped back, but we are still front line. We don't need a grace period. If I were a judge, one of the first things I would get angry at is a lawyer who didn't comply with a rule that they've had 11 years to learn the rules on. It's a complex rule, but folks, it's not that hard. It's not that hard.
Oh, it's not that hard, but I've talked myself in circles today. I want to clarify that the probate It's a CP case is the case that, and that's not a CA. So the CA, I misspoke when I said that we are no longer redacting in those cases independently, because we are. It's the CA cases, the CCs and the SCs. So if I haven't thoroughly confused everyone on that by now, I'm sorry. But
so if you want to file sneaky stuff that's all kinds of confidential, send it to Marion County. You can get anything in the file up in Marion County.
test me, Paul.
No chance, Greg. No chance. You're too quick.
So just to be clear, probate cases and guardianship cases, we do continue to do the redactions in those.
Yes. Thank you, Angel.
Okay, so our next question is, what is the clerk's obligation to review a filing for confidential information when the filer has omitted the location on their notice?
Clerks?
That goes to the incompletion of, that's not a complete notice of confidential information if that's omitted. There were, I believe one of the clerks, part of the statistics that you saw was just that a blank piece of paper would be filed. It would be half filled out with no location identified, and that's not considered a complete notice of confidential information.
And I think in the statistics that I shared, Clerk Colony, so that those two clerks' offices alerted that filer that either it was incomplete or not in compliance.
Correct.
That's right. Clerk's offices will typically work with a filer if that is the issue. Our stance on this, are essentially our majority position among clerks on it, is that the rule amendment requires filers to file a notice pursuant to the rule, and the rule requires identification of the location of the information. So to file a notice pursuant to the rule, it's our position it has to identify the location.
But I think what Greg is saying is that the clerks don't just throw it away and trash it if you haven't done your job. They know you're trying to keep something confidential. They will do their very best to work with you. These folks are our friends. We may have fought like cats and dogs 12 years ago, but we have become friends. We work together and they built this system. They don't want this information to become public, but they are ministerial officers. They are not judicial officers. They cannot make decisions. They can only work within their very narrow powers. And when you've stretched them beyond that, that's as far as they can go. They will work with you. They're extremely cooperative in that regard.
And to the extent we're running out of time in the presentation, Clerk Colanesso, Clerk Moore Russell, if we have some unanswered questions in the Q&A portion, maybe we could work together to make sure that we get everybody's questions to the best of our ability. So even if we're not able to do it here, we do have their names and I'm sure their registration information, so we could follow up afterwards in that regard.
Okay.
Yes, maybe we could even have somewhere where it's posted with the question and answers so everybody can benefit off of that.
So we might only have time for one more question, but the last one that we have is, what if a filing has both information that falls under the 23 categories and the other 970 types of information? Should I file both a motion and a notice?
Good, excellent question. I don't know if that ever happens, but absolutely. You want to get your 23 category information handled quickly, because that's simply a matter of saying, again, page 37, paragraph 72, part A. And the clerk looks at it and says, oh yeah, social security number, I see it right there. Bam, done, confidential. The other is held and goes to the judge. You have to schedule a motion, a hearing, excuse me, on your motion to determine confidentiality and convince the judge that this falls into some unusual statute and that therefore should be confidential, the balance of the document, in a case context. So yes, you will need to file both of them. I mean, think of business trade secrets. There's tons of cases that have lots of information, and frequently they may have some of the 23 in it as well. That's really an excellent question.
Thank you, Paul. I think that's really all we have time for. Clerk Colanesso, did you want to close it out?
Just thank you, everyone. Thank you to the panelists. Thank you to both the Florida Bar and the FCCC for providing the support for this. And we hope that everyone got a lot out of this. Our intent is, there are a lot of questions as I'm looking at all of this, too many to answer right now. So hopefully we can all work together to post these question and answers where it'll be helpful to you, or some type of follow-up to the registrants. But we are committed to getting you answers to your questions. Know that.
Can I say one thing?
Yes, Paul?
We've had somewhere between 400 and 450 participants in this. That's 0.45 of 1% of the bar. The way I'm seeing this, 85% of the bar doesn't know what they're doing. Folks, you now are the skilled set. You know what you're doing. Please spread the good word. Thank you.
Thank you. Oh, the CLE credits, I'll add this. The CLE credits, are they going to be given out? Patrick or Jonathan, do you have information on the CLE credit for this?
Yes, I do. I'll get that course number for you 1 second.
Okay. Will something be sent to the applicants, the registered?
Yes, we can send them the CLE information
Okay.
along with the from today.
Okay,
Great. Thank you all.
thank you.